Good afternoon, everyone. Good afternoon, everyone. Thank you for joining me today. I'm Richard Goldhar, and I'm with Goldhar and Associates. I'm a licensed insolvency trustee. My license was issued by the Office of the Superintendent of Bankruptcy, and I'm here today to share with you a little bit about personal insolvency pertaining to consumer proposals. Please use the chat feature to talk with me, or please just raise your hand so I can answer any of your questions. The purpose of the Bankruptcy and Insolvency Act is to provide for financial rehabilitation of an insolvent individual. That's an individual who owes more than $1,000, who is unable to pay their debt as it ordinarily comes due, or is somebody that is unable to pay their debt in the general course of life with selling off all their assets, their cars, their trains, their planes, their boats, their cottages, their land. This legislation is also here to permit honest and unfortunate debtors the opportunity to discharge themselves of unsecured debt and allow themselves a fresh start and resume their place in business and in the credit environment. I always am asked a question, what does insolvency mean according to the Bankruptcy and Insolvency Act? The definition is when a person, an individual, or a corporation who is not bankrupt and resides or carries on business here in the country of Canada, and more importantly, in whichever province they live in, and owes creditors at least $1,000 or more. Who is insolvent? A person who is insolvent for any reason is unable to meet their obligations as they generally become due, has ceased paying their current obligations in the ordinary course when they're often required to pay them. A credit card payment that's due on the 28th of each month, if you don't have the money to pay at least the minimum balance, that would be an example. The total sum of a person's property at a fair valuation is not sufficient to pay out all the creditors whom they owe money to. I'm going to highlight a few important definitions that I suggest we all discuss. A bankrupt. That's a person who made an assignment or whom an assignment was made against them for a purpose of a bankruptcy and is a legal status change in their natural place. I see a question, so I'm just going to look for it. Thank you, Miriam. A creditor. This means a person who is owed money or having a claim provable in the insolvency process. A proposal. It's always the friendly term. It's a formal arrangement under the Bankruptcy and Insolvency Act, which in essence combines all the unsecured debt to one easy payment payable over a 60-month period. Options available to individual with debt issues. As a licensed insolvency trustee, this is where we come to play. We are the only individuals licensed by the Canadian government through their organization of the Office of the Superintendent of Bankruptcy to deal with three major ways to deal with debt. There's a bankruptcy, so that's when the individual makes an assignment, or as I said prior, there's an assignment against the individual. There's the proposal, and that's offered by a licensed insolvency trustee as well. There's informal settlements that a licensed trustee in bankruptcy can deal with, or a lawyer can deal with that as well. There's also debt management plans, which are also offered by credit counselors under a non-profit credit counseling agency or a for-profit credit counseling agency. They are not charities. It's merely another option to dealing with your debt. In that form of debt settlement, you cannot reduce the principal amount owing. In a proposal and in a bankruptcy and an informal settlement, you are able to reduce the principal amount owing. Another option would be to deal with budgeting. When folks call our office, we have 5 credit counselors on staff who are able to help individuals with their monthly budgets. At times, this is able to save them from filing a debt management plan, a proposal, a bankruptcy, or an informal settlement. There are folks that want to do nothing about their debt. That's okay as well. I understand everyone has different ways to dealing with situations. All I ask is that they give us the opportunity to talk to them because we are licensed. We have spent the time in school. We have spent the time learning about the processes, and we know what's right for individuals. Common reasons cited for insolvency. There's employment issues, there's income issues, there's money management issues, health issues, relationship breakdowns, business failures, overextension of credit, family and child issues, addiction and gambling issues, a guarantee of debt by others, director liabilities when companies have issues, namely for HST and payroll, income tax and CRA audits, fraud, legal issues, and death of a spouse. There are many other reasons. These were just the ones that came to my mind and the ones that we see often in our practice. The role of a licensed insolvency trustee. We have a list of objectives, and I'm going to explain to you what we feel are the key objectives in which we are able to assist individuals and corporations. We assist an individual through the bankruptcy or proposal process by providing and educating them with the rules, regulations, and compliance requirements. We have lots of that information on our website at shedthedebt.ca, and you can also look for more information at the Office of the Superintendent of Bankruptcy's website. We help prepare the Statement of Affairs. That's the list of the individual's assets, their liabilities, and other pertinent information. We'll review this information with them at the time of our assessment. A licensed insolvency trustee must make an assessment of an individual for filing a proposal or bankruptcy. There are only currently 1,100 trustees across the country of Canada, and we are so happy to have 6 of them working here at our firm at Goldhar and Associates. We investigate the financial affairs of the individual. We provide free credit counseling advice. We pay out dividends as required both in a bankruptcy and in a proposal. We comply with all the BIA rules and directives of the Superintendent of Bankruptcy. We're officers of the court, and we're here to help individuals and businesses on an as-needed basis. In a consumer proposal, we provide the legal framework for individuals to provide an opportunity to negotiate a new payment arrangement with their creditors. This is when you often hear people saying, I pay 30% of my debt back, I pay 20%, I pay 60%, I pay 50%. The rationale for those numbers all stem from a trustee doing its job and looking at what would be paid in a bankruptcy and what would ought to be reasonably paid in a proposal. Creditors vote on the process, whether or not to accept the proposal, to counter the proposal, or reject the proposal. Lucky for us here at Goldhar, our proposals are either accepted or countered 97.6% of the time. The ownership of the assets remain with the individual when they file a proposal with our office. Debtors have the option of payment terms to a maximum of 60 months, but we're often seeing creditors who are able to find ways to have family support, make quicker payment arrangements, have an ability to get a better job because they're now no longer stressed or have health issues. And as a result, they're often done these processes in as little as 1 month and sometimes to a maximum of 60 months. When filing a consumer proposal, you also get what's called an automatic stay of proceedings. This helps the debtor. It allows them to stop wage garnishments. It allows lawsuits to stop. They can't issue any lawsuits. And it allows them the opportunity to breathe and get back to normal life. What I do remind individuals is that consumer proposals are only able to help unsecured debt. However, in a proposal, if you sell your home, for instance, and the mortgage is $1 million and the house only sells for $600,000, the $400,000 shortfall will become unsecured, and you could deal with that in your proposal. There are different types of debt that do survive a consumer proposal. They would be separation payments, child support, speeding tickets, court-imposed fines, any fraud. Are there any questions currently? I'll just wait a moment to see if any questions show up on the screen. I do see one. Is there any penalty paying off a consumer proposal earlier? There is no penalty. It's great if you're able to pay off that consumer proposal early. It'll allow you the opportunity to close your file out. With regards to credit agency reporting, this trustee does not report at all to the credit reporting agencies. We report to the Superintendent of Bankruptcy, who in turn reports to the credit reporting agency. So it will report on the filing and it will report on the discharge of the matter. So the sooner you pay us off, the sooner it will report to the bureau that you've paid out, and then you're able to start to rebuild your credit to a great score. Thank you for asking that question. I'll wait one more moment to see if anybody else answers any more questions. Okay, we will continue on. A consumer proposal is only able to deal with individuals who have unsecured debt in the amount of $250,000 or less. If you and a spouse are filing, that'll be up to $500,000 of unsecured debt or less. This does exclude the mortgage on your principal residence only. So if you have a cottage, that mortgage would fall under the unsecured amount of debt only for the amount to calculate the proposal terms. With regards to approvals of proposals, we need the majority of creditor dollars to vote the proposal through. In Canada, many of the creditors have hired proposal voting houses, claim houses. This will allow for a more expeditious way of dealing with proposals. So what that means is the creditors typically will hire what's called Bankruptcy Highway, First Canadian Title. Those folks consolidate all the claims and they vote on behalf of the creditor. It's a really good process. Up until COVID, you had a provision in proposals that anybody could miss up to 3 payments at any time along the proposal process, as long as they were made up by the 60th month. So if you missed month 1 and 25, you could make it up before the end of the 60th month. However, if you missed 3 payments or more, the proposal would default itself. There are 2 mandatory credit counseling sessions. I find the information very valuable that you're going to learn in them. I have sat through many credit counseling sessions. I have done many credit counseling sessions. It's a great way to chat with individuals, learn more about how to budget, learn more about how to deal with your debt, learn more about the credit reporting agencies and how to get credit cards. It's really, really great information that you'll get in it. And you'll get a booklet at the end that you can keep so that you can refer back and remember exactly what to do. There's just 2 more questions. I'm going to answer them. If you miss more than 3 payments, the proposal will annul itself. That means the debts will revive, the creditor's rights will revive, the automatic stay will disappear, and what will happen is, in order for you to reinstate the proposal, you would need to contact our office and we'd put you in touch with the right folks to reinstate it. I do suggest if you're falling 2 months behind, you contact the office right away to see if we can make some alternate arrangements. During COVID, how many payments can be missed? During COVID, the Superintendent of Bankruptcy has issued an interim directive up until the end of September, which just passed, saying that you could have missed up to 6 months payments. It has to be renewed, and we're hoping for an outcome shortly from the Superintendent of Bankruptcy. I'm just waiting to see. What I do remind everyone is there is no additional fees to talking with a licensed insolvency trustee. Our fees for proposals come from the amounts being paid to creditors. So if the proposal is structured for 10,000 or 6,000 or 16,000, we get paid a percentage of that money by the creditors before we make distributions, but it is not to be paid by you yourself. I'm going to skip over the bankruptcy stuff because that will be our next presentation, which will be next Thursday, and hopefully you folks can join us for it. What I wanted to go over is that the proposal process is a creditor-driven process. What do we mean by that? Creditors are requested to vote on the proposal offer made by the individual. As I explained to you, there are three major voting houses in Canada in which most creditors have had the opportunity to work with. We know that they are very reasonable and that it's much easier to deal with three creditor houses than it is to deal with individual creditors who might not understand the process and what they're looking for in the process. Creditors are encouraged to request a meeting of creditors if they have more questions for the individual. This process will stop the rejections. So often what happens is that they have an ability to talk to a creditor, and now it's done all virtually. It allows for the smooth acceptance of proposals. Creditors can appoint a maximum of 3 inspectors for a consumer proposal. Inspectors operate as a pseudo board of directors. So what that does is it allows the administrator or trustee in the proposal process to be able to have just a smaller creditor group to deal with when trying to resolve matters. Now the question is, why would you pick Goldhar? So Goldhar is Ontario's fastest growing insolvency trustee firm for an independent owner like myself. We're not part of a big accounting firm. We are fast and we are flexible with dealing with all the client's needs. Most importantly, we're friendly and we listen. You get to speak with myself and any of our 6 other trustees on staff and our amazing 25 administrators on staff. We're all here to help you. Our professionals are effectively regulated by the Office of the Superintendent of Bankruptcy and our professional body, the Canadian Association of Insolvency Restructuring Professionals, which ensures that we keep to the highest professional standards and we have consistent competency. Goldhar Shed the Debt professionals will travel to consult with you anywhere in Ontario. We have 17 offices across the province of Ontario. Like I said, we have over 30 staff working with us. We are open all the time, 8 a.m. to 7 p.m., Monday to Friday. We're open on Saturdays from 9 to 4. We will talk to you via video link. We'll talk to you by phone, via email. However you need, we are able to talk to you. Do you have any further questions for me? Okay, if you have no further questions, I do thank you for joining me. I look forward to seeing you at our next event next week where we'll learn more about bankruptcy. And again, thank you for listening to me, and please feel free to reach out to our website or reach out to me directly at pound debt on your mobile device. That's pound 3328. Or you can email me at rgoldhar@goldhar.ca, and I'd be happy to respond to your questions. Thank you.